Some new information now on the case of a Saudi prince arrested in Los Angeles last month for allegedly trying to force a female worker to perform a sexual act. Days later, 3 women filed a civil suit accusing the prince of extreme and despicable behavior. But late yesterday, prosecutors announced they will not file formal charges due to lack of evidence. Let's talk about it with Lise Wheel, our Fox News legal analyst, whom you know. Robert Bianchi is a criminal defense attorney, a trial attorney, and a former prosecutor. Does this have anything to do with diplomatic immunity, Lise?
It may, but I think really here with the evidence, because there really isn't a lot of strong evidence. It's a he said, she said, and the problem, as you mentioned, they filed a civil lawsuit. And that's tough for a prosecutor getting over it, and it looks like it's just all about money. So what I think they should have done here, rather than say, we're just not going to charge him, is go to a grand jury. The prosecutor can always use the grand jury as kind of a buffer. If the grand jury says no indictment, well, then you don't charge. If they say indictment, then you charge.
But one of these women, Bob, was reportedly found, crawling over the fence of his compound, screaming she was bloody, trying to get away from this guy. Is that not evidence enough?
Yeah, John, listen, as the head prosecutor for many years, you would get cases very much like this. It would come in, it would look like one thing. But when your detectives and investigators go out, witnesses recant their testimony, they change their testimony. We just don't know yet specifically. But I agree with Liz that when you have a situation like this, it's valuable to put the case into the grand jury so that the grand jury can listen to all the evidence, all the witnesses, any contradictions in their story, and they can make a decision.
And the problem, too, with the witness, because I agree with you, that's the strongest evidence. There's that woman that's trying to scale the fence, and she's all bloody and she's screaming. That, unfortunately, though, can be explained away by, oh, I know I'm kind of getting on the bandwagon here. I'm going to sort of make it up even. And if the prosecutors thought for 1 minute that was going on, they're not going to charge. On the other hand, I will tell you, as a prosecutor, the worst thing is when you know someone is guilty, but you don't have enough evidence to charge. That means go back to the grand jury, let them decide.
And something I find interesting here, John, is that the prosecutor didn't just dismiss the charges completely. He actually remanded it or put it back into the municipal court. So there's another lower prosecutor's office that's going to evaluate the conduct. What that says to me as a former prosecutor is that they didn't feel that the conduct that they knew about at the time they could prove amounted to a felony, but may have amounted to a lower offense. So it's not completely over for him yet.
Right.
And he has a civil case, and me and Liz were talking about this.
Right.
In the civil case, he has a Fifth Amendment right not to testify because he may be implicated in a criminal case, but if he refuses to testify in the civil case, he could have a judgment actually filed against him.
And it's a lower burden, obviously, and so, paychecks.
We'll keep an eye on that one and let our viewers know what happens. I want to take you to the case now of a Utah pediatrician who is appealing his murder conviction in the death of his ex-wife. Dr. John Brickman Wall was accused of attacking her with a knife, dosing her, I should say, with the anti-anxiety drug Xanax, and then drowning her in a bathtub. Here's the moment when the verdict was read at the trial back in March.
We, the jurors in the above case, find the defendant, Johnny Brickman Wall, as follows. Count 1, criminal homicide murder, guilty.
We have spent the last 3.5 years seeking justice for my mother, and today that quest is finally ended.
Pretty powerful statement there from the son of this couple. The parents were divorced. He is convinced that his father killed his mother. The father wants a new trial.
Right. It's not going to happen. The standard is so high. And when you've got his own children coming out and saying, finally, justice for my mother, that speaks volumes. The standard would have to be something like new evidence that comes in that just totally exonerates him, or DNA that exonerates him. None of that's here. He just wants to appeal to get a new trial. It's not going to happen.
The thinking is, the prosecution theory was that he crushed up some Xanax tablets, put them in a big syringe, and basically squirted them down the throat of his ex-wife. But there was testimony at the trial that there were whole tablets found in her stomach that had not been digested yet, that could not have happened if they had been administered in the way the prosecution thinks they were.
Hey, John, it's amazing. I actually had and tried a murder case in which listen, women mainly are killed in the bathrooms. It happens over and over again in murder cases. So the investigators should have been very, very quick not to move this as a suicide. I can't tell you how many cases have been closed out for suicide or accidental deaths when in fact they were homicides. But the bottom line is, it doesn't make a difference if she had the drugs or not. The jury got to listen to that testimony, evaluate the witnesses that testified, suicide, you will never get a case reversed because the expert was wrong or right. That's what juries do. They evaluate the evidence.
And his reaction after she was found, sort of, very strange with the children, and that all played into it. And I agree with you. Remember the Peterson case, not Scott Peters, the Peterson case, where the second wife, the autopsy was opened up because it was not an accident.
We have a snippet of the police interrogation of the doctor. I want to play that for you now.
The reason why you don't want to remember is because you killed her. I knew that took her life. No, you did not. You took your children's mother's life. How can you say that? You did it. That is not true. You absolutely did it. Absolutely not true. I hope I would be self-aware enough to know that that's happening. But sometimes it just gets out of control, Johnny, where sometimes
it really is an out-of-body experience.
Accident. It becomes an accident. But I don't think I did it.
I don't think I did it. That's hardly a, that's
Right.
not what we heard in the first snippet of that interrogation. What does that say to the jury?
John, this is homicide investigation 101. He has to speak to the police because he's saying it was an accident, it was a suicide. So the police have an easy introduction to speak to him. But when he equivocates and says, I don't think I did it, there is nothing more powerful in the prosecutor's world than admissions like that. And that's exactly what that is, that come out of the mouth of the defendant himself.
Because if he didn't do it, he would have said, adamantly, I
that's
didn't do it.
That's what he said in the first
No,
part.
but you would never then go back and say, I don't think I did it. That would never happen if you really believe that you weren't guilty.
Wow.
Would never happen.
Both of you agree he's not getting a new trial.
Totally.
The appellate division is going to look at this case, and even if there was an error made by the court, they're going to say there was such overwhelming evidence that to point it towards
Any
guilt,
kind of
that's not
error
gonna
was
make a
just
difference.
minimal,
It was
right.
minimal, right.
All right. Bob Bianchi, Elise Wheel, thank you both.
Got it.
Pleasure.